Hey, everybody, and welcome to Thursday night. Here we are, Thursday Night Live once again. My name is John Skiba, and I'm a consumer protection attorney and a bankruptcy attorney in the state of Arizona. And each and every Thursday night, we meet here and we have discussions on defending debt collection lawsuits, bankruptcy, all those kind of things. Over the almost 20 years of my legal career, I've done a lot of focus on defending lawsuits against junk debt buyers like Unifund, Portfolio Recovery, Cavalry, Midland, all those guys. And so that's a big topic that we talk about here on the YouTube channel. If you have questions, go ahead and put them in the chat section, in the comment section, and we'll discuss them today. Even though I am a licensed attorney, I am not licensed in the state. I'm licensed in Arizona, but not any other state. And so anything I'm providing you here is just information. If you need legal advice, absolutely, you need to find an attorney in your state, meet with them specifically. This doesn't create any type of attorney-client relationship. We're just chatting on the internet about legal things. So if you do have questions, again, just put them there in the chat box and we'll go over them. I see we already have a number of them here today. A couple things that I wanted to show you. First of all, before we get into the questions, I mentioned last week that I've opened up the Facebook group. It's a private Facebook group, the Consumer Warrior Facebook group that's dedicated to just allowing people to kind of take these conversations. I was going to say offline, but we're really just going from online to online on a different platform that's a little more conducive to be able to provide discussion, and people can provide input from their experience. There's no charge to do that. To be able to do that, you just go over to facebook.com/group/consumer warrior. And I will approve you. There's a few little questions you have to answer, but then I'll approve you to let you in. And then feel free to just discuss with everybody else kind of what's going on, tips, tricks, all that kind of stuff that we're trying to figure out on how to deal with serious debt problems on that. I'll put that up also, but you can also just go to Facebook and put in Consumer Warrior, and I'm sure the group will pop up, and you can request to be on that. So, man, we already have people jumping in. We got Dave Lamb, who's contributed each and every week. Big fan of the channel here. Appreciate that. Same with Michael. I appreciate it. We've got some good feedback from Michael saying that he ended up settling his case at a very, very favorable price due to the information we provided. Thanks. Thank you, Michael. I appreciate you supporting the channel. I'm glad you're able to get that taken care of, squared away for you. So, all right, let's jump into. I want to hear with my man, Natus, if I'm saying that right. Because I know you had a question last week and we couldn't see it for some reason, and I wasn't able to help you. So I wanted to go over your question. Let me make sure. I think I saw this. It's kind of a two-parter. Okay, yeah, here we go. So arbitration grant. So if this is a debt collection lawsuit situation, and you've asked the court to compel private arbitration. At the very top of the comments there, you'll see I have pinned the link to some of my online tutorials, which are going to a lot more depth, obviously, than we're going to go into here on a YouTube channel. But one of the most popular ones I have is getting your debt collection lawsuit dismissed by using or compelling private arbitration. So that's what sounds like what's happened here is you went and filed a motion to compel private arbitration. That's granted. However, you still received requests for admissions, production of documents, interrogatories, and all that written discovery type stuff. Should I ask for settlement? File for arbitration if they don't settle. If I'm getting your question right, if arbitration has been granted and they're still sending you discovery responses, I can tell you the one thing. It depends on whether the court left the case active or whether they actually dismissed it, or if they just put a stay in place. I always err on the side, particularly with requests for admissions and just responding to them. Requests for admissions in most states they have a penalty if you don't respond to them timely. And the penalty is harsh. What it is, like, for example, in Arizona, you have 30 days to respond to the request for admissions. And if you don't do so timely, those requests are deemed admitted. And debt collectors know this. And so they'll often put requests for admissions like, admit you owe us $10,000 or whatever they're seeking. And then if you don't deny it, or if you, a big one they have is admit that all the documents that we have are admissible in court. Then they will try to use that against you if you don't respond to it. So I typically recommend responding to those just to be on the safe side. There's, you can ask for settlement. I know you kind of had a two-part thing here. Should you ask for settlement? And then if they don't settle, then go file the arbitration. You could do that. Settlement discussions are never a bad idea. In civil cases, settlement discussions cannot be used against you. So, the rule is there. It's Rule 408 of the Rules of Evidence in the federal and in most states. The idea is they want the parties to talk. They want them to try to resolve this. But so they want you to not be afraid to talk because you're afraid they're going to go run into court and say, hey, judge, they already admitted they owe X, Y, and Z. They might as well, they clearly owe the full balance. You don't have that fear, so you can reach out. And if not, then file it. If you don't file on it, a lot of it depends on what the judge is asking. Now, sometimes when you ask for arbitration, the judge will just stay and say, okay, we'll stay the lawsuit, and then say, go do what you're going to do. And then you kind of get into this duel, who's going to file first, because the debt buyer doesn't want to file because there's going to be huge expenses associated with it. You don't want to file because there's some costs. It's not as much as them, but they don't want to. So it kind of gets into this thing. Go look at that arbitration clause. A lot of times it says that the party who has a claim against the other one is the one who has to file. They have the claim against you. Clearly, they filed this lawsuit against you, so you should pursue that and make them be the ones that actually file it. All right. So thank you for that question. Let's see. Tiffany here says, if your house equity is over the state exemption in an amount, for example, $3,000 to $5,000, would they still take it? And can you get a realtor to appraise the value if that issue arises? All right, Tiffany, thank you. So I think this is a bankruptcy question. In a Chapter 7 bankruptcy, the idea behind Chapter 7 is you're going to get rid of all of the credit cards, medical bills, all that unsecured debt's going to go away completely. The trade-off is the court or the bankruptcy trustee really is going to look to see, are there any assets that they can take and sell and give the money to your creditors? They're going to try to liquidate assets. Most things are exempt. There's all these exemption laws in the state, and the federal government has some exemption laws. Like your retirement account, your 401k is protected. It's protected. Your home, the homestead exemption, a lot of people have heard of that. But if the value of your asset is more than what the homestead exemption protects, or the exemption for vehicles, or the exemption for household goods, or whatever, the question is, are they going to take it? So Tiffany's given us a question here, is if the equity in your home is over the state exemption by just like $3,000 to $5,000, are they still going to take it? And if so, can you get, essentially, can you contest the valuation of it? This is a huge thing, particularly here in Arizona, because everybody's equity in their house is skyrocketing. So much so that the homestead exemption actually changes. Right now, Arizona's homestead exemption protects $150,000 of equity. Starting January 1st, 2022, it goes up to $250,000 in equity is protected. And you gotta, if you're not in Arizona, you got to compare your state. I know there's some eastern states. I swear it was Tennessee that had like a $15,000 or $20,000 homestead, which I don't know how that works. I don't know how anybody could keep their home, but you need to make sure that's a state specific thing and can cause big problems if you don't pay attention to that. So the question is, if the equity is just $3,000 to $5,000 over, I can tell you most bankruptcy trustees, they are going to take into consideration they run essentially a hypothetical sale. They take into consideration closing costs, realtor fees. And so if you have, like in Arizona, the homestead's $150,000 of equity is protected. If you have $153,000, $155,000, you're probably going to be okay. Because if they were to run a hypothetical sale on that, those things are going to dig into that equity. You're going to probably pay $6,000 in commissions. You're going to pay another probably $2,000 or $3,000 in closing costs, or $5,000 in closing costs, all the title fees, all that kind of stuff. So, and that will bring you down below it. So definitely something to talk to a bankruptcy attorney about in your state. Make sure you know what the exemption is and kind of what the practice is or the custom is of trustees and going after big dollar assets like that, because that could make obviously a pretty, big difference in that. So, all right. I'll do a real quick follow-up here, Tiffany. Does an attorney have to write a consent to talk to letter to the mortgage holder in order to continue with payments for the person filing Chapter 7? And I know I kind of just mumbled through that. This question, this is one of these things that I understand, obviously understand the law, but it's just really annoying. Once you file for Chapter 7 bankruptcy, you have an attorney, the mortgage lender is going to say, we can't talk to you directly. We got to talk to your attorney. And so, the attorney should be willing to kick out a letter saying, hey, you can talk with them specifically about, taking their payment or making sure that they send them the monthly statements, that kind of thing. So, all right, let's see what Ray has. I have a letter from a law firm for a collections on a closed credit card I fell behind on in 2020. Should I be more worried about that than any other type of collections letter? Usually, most law firms don't do a whole lot of just, calling you on the phone, sending you letters. They'll usually send what's called a pre-legal letter where they're going to file a lawsuit. A lot of it's going to depend on who the creditor is. And, if it's something where an attorney's office is involved at this point, the next step is probably going to be a lawsuit. Is that going to be a month away, a week away, a year away? I don't know. But it's probably something to take a look at and see, depending on if it's a debt buyer, original creditor, look at different settlement options. But usually once the law offices have it, they don't, if it's a true just collection law office, they're in the business of filing lawsuits, getting default judgments, and garnishing people's pay. That's what they do. And so they're not going to usually just, send you tons of letters. It may just be a shot across the bow, but I would probably take that one more serious. Let's see what Antonio has to say. LVNV is suing me now, and I emailed their home company and haven't heard from them. I asked them for the purchase agreement, and I'm waiting. LVNV, so first of all, if you emailed them, trust me, I've done this stuff before. If you're not emailing their attorneys, it's like throwing a pebble in the Grand Canyon. These big companies, I think these things, I don't even know if they actually go anywhere, some of these email addresses. And it actually is a good question that follows up on a comment I saw on the YouTube channel, where sometimes when people get sued by someone like LVNV, they say, hey, you know what? I'm not going to deal with this junk debt buyer or their lawyers. I'm just going to call the original creditor. I'm going to call Synchrony Bank or whoever the original creditor was. It's important to know once they have legal counsel, you're going to have to go through the attorney's office. You couldn't even call LVNV or maybe email them like you're doing here. So, Antonio, I would recommend if you're trying to contact them and for whatever reason, asking them for documents, it needs to go through their law office. If you're to call them up, they're going to say, hey, we have counsel at this point. You need to go through them directly. So that's what it's frustrating, but that's the way that you're going to have to take that approach here. All right. Audrey May, regular here. Appreciate it. Can I explain a break in the chain of title? Yes. So chain of title issues show up in junk debt buyer lawsuits. So the junk debt buyer is alleging that they purchased this debt from Chase Bank or Wells Fargo or, whoever, Citibank. They're saying that they bought a big group of portfolio debts. They pay pennies on the dollar for them. And they're saying they bought these with the right to sue on them. So essentially they're kind of stepping into the shoes of Citibank or whoever, and they're going to sue you to try to collect on those money. So they pay very little. They hope to sue you for the full balance, get that back. And that's how they've chosen to make a living in this world. So when they go into court, they have to prove a handful of things. They have to prove that you had the original account. They have to prove that what the terms are, that you breached those terms, and they have to show what the amount owed is, just like the original creditor would. But a junk debt buyer has the additional step that they have to prove that they own it. They have to show that it's actually because I always say there's no what we call a privity of contract. There's no agreement between you and Midland Funding. They didn't loan you money. You didn't agree to pay them money. So why should you pay them anything? Well, they've got to prove to the court they're the actual owners of the debt at this point. And they have to do that through a chain of title. They have to show how this account went from step A to B, all the way. And the issue, it becomes particularly more difficult when there are multiple debt buyers, because often these cases are bought and sold and bought and sold. So let's say that original creditor, the account's there. They have to show that your specific account, not just some general accounts, but your account was transferred from the original creditor to the debt buyer. And then they're going to have to show if there's another transfer from that first debt buyer to the second debt buyer. And a lot of times what you'll see, particularly when there's multiple transfers, you'll see that they'll have a bill of sale saying Citibank sold all the accounts listed on Exhibit 1 to, whoever, Unifund. But then there's no Exhibit 1. There's nothing. But then there's a second bill of sale saying, and Unifund sold all of their accounts to Cavalry SPV, attached as Exhibit A. And then there might be like some kind of spreadsheet. The chain of title, you've got these links in the chain. There can't be any break. They have to show that your specific account was transferred between the various entities. So look at the bills of sale and see what accounts are transferred. Like I said, I've done probably 400 trials. I've done thousands of these cases. There isn't a bill of sale anywhere that's going to say your specific account because they're transferring thousands of them when they do this. But the bill of sale will say that the specific accounts are attached as Exhibit A or Exhibit 1 or Schedule 1, or sometimes they'll say that they're included in the Master Purchase and Sale Agreement or the Forward Flow Agreement, something like that. They've got to show that your account was transferred, not just that a big group of accounts was transferred. That's not sufficient. So that's what we mean, Audrey, by chain of title, is if there's a break, if they don't show that your specific account was transferred between two of those entities, that's a break in title, and it means everything else that follows should be able to stand. So, all right, let's see here. What kind of information letter would my brother and friends receive once I file for bankruptcy 7? When I list them as my creditors? Is there a form I can look at? All right, so when you file any kind of bankruptcy, Chapter 7, 13, whatever, you're required to list all your creditors, even family, friends, things like that. If you owe them a lot of money, you got to list them out as a creditor. As far as what they'll receive a notice that you filed. The bankruptcy court will send out a letter, and it will actually provides a date for the meeting of creditors, the 341 meeting we call it. It'll say, John Skiba filed Chapter 7 bankruptcy on this date, and we'll give him the date for the meeting of creditors and some other information as far as some deadlines. And that's it. That's what they get. And in most cases, they don't get anything else. They may get a copy of the discharge order once that comes through. So, all right, let's see here. Debt collector is suing me for the credit card debt they bought, called to settle the debt. $5,400, and I offered them $3,000. Did I do the right thing, or I just need to file an answer and go to court? This is a good question and I actually had a bunch of comments I was looking at in the channel today that talk about this specifically. And really, most of the questions are like, can I reach out and try to settle this before I file the answer? If I do settle it, do I still need to file an answer? Because you got to remember, 95% plus of debt collection lawsuits, the creditor wins because people don't file an answer. If you don't file a written answer to the allegations, and I have a tutorial on that. It's my number one selling tutorial. That shows you how to draft that. You've got to file that document, excuse me, with the court to avoid it. So if you settle there's no problem in reaching out and trying to settle the case before your answer is due. You can reach out to the attorney. And like this one, they're saying there's $5,400 owed. You're offering them $3,000. If that's a junk debt buyer, they should take that. They should take even less, I think. But you can offer to settle. And if they say, great, as long as you get it in writing, you make the payment, they'll dismiss the case, make sure it's dismissed with prejudice, meaning it can't be filed again. And they should do that. I don't see a lot of law offices that aren't willing to do that. So once you take those steps, then you're good to go. But if it's getting near the deadline and you have to file your answer and you're still kind of going back and forth, or the settlement isn't complete yet, I would file the answer just to be safe. Because filing an answer buys you time. So you can still continue to try to negotiate it. And if you settle it, great. Then, the parties will agree to dismiss it and you're done. But if you haven't settled it and you don't file an answer and they get a default, then you've lost a lot of leverage and you've opened yourself up to a lot of other issues. So, all right, Alex, you made it back. Thank you from Yuma, Arizona. I got to get down there sometime. This is the time of year. Arizona's finally cooling off. It's not 1,000,000 degrees. I don't think it's even 1,000,000 degrees in Yuma, which is the hottest part of Arizona. All right, let's talk about student statute of limitations to file a suit on utility debts. Now, statute of limitations is important to know. That is a state-specific statute. Because I know Alex here is in the great state of Arizona, where I practice, we can talk about that. But depending on where you are, that's totally state by state. So you got to be careful with that. Now, in Arizona, the statute of limitations in general is 6 years on anything that has a written agreement associated with it. And written agreement in the world today also means like when you go onto a website and click a thing to have a credit card, or those terms and conditions, they have you check the box that you accept. That's going to be considered a written agreement. Utilities are going to fall into that as well. That they've got a written agreement that they can file suit 6 years from the date that the account goes into default. If they don't file the lawsuit within that 6-year window, then they're barred forever from doing it. But so that you understand, it's like an oral agreement in Arizona is a shoot. Now I'm blanking. I think it's a 3-year statute of limitations. But then there's other things like FDCPA claims. They have a 1-year statute of limitations. So you got to be really careful when it comes to those things. So, all right. I think we got most of the questions here. We're running up on 20 minutes, but I think we'll end there, Alex. We'll end on that question. I appreciate everybody checking in as always. Let me give you one more time that Facebook page. Go over there, sign up. No charge to do it. Become part of this. It's a private Facebook group where we can discuss these things in a lot more detail. Again, if you look at the top of the comment section on the YouTube channel, I have pinned there our advanced online tutorials that can help you kind of really do a deep dive in a lot of these different things. Of course, Alex, am I going to watch the Cardinals game? I got to get home to watch it. It's almost time. They're playing Green Bay tonight. It's a big game. Although I heard J.J. Watt is out. So we're going to have to see what's going on there. Appreciate everybody checking in.